board. It's another time with a fantastic tutor, and in today's tutorial, it's going to be a continuation of the course POL211, and today we're going to be talking about the rule of law. With this being said, let's go straight into it. So we have taking our bearing from the rule of law, and we're going to be talking about what it means by the rule of law and some other topics after it. Now we have the rule of law is one of the cardinal ingredients of political or democratic governance. One of the cardinal, said to be one of the cardinal ingredients for what we call political, and democratic governance. One of the cardinal ingredients, said to be one of the cardinal ingredients for political or democratic, political or democratic. Good evening, Miss Regina. It's great to have you on board today. How's work been, ma? Miss Regina, I've not been getting your note lately, and that is really unlike you. I believe it's you have so much busy schedule, if I'm not mistaken, because I know you do updates on that. Now, political governance largely refer to rule, largely refer to the rule by the people, either directly or through representative governance. Now, what are we talking about here? About the rule of law. It is said to be a constitutional doctrine that emphasizes the supremacy, over everything within the states. Now let's take this down. Just a moment. Trying to. I have that. One of the cardinal ingredients of what we call. One of the cardinal ingredients of what we call of political and democratic, of POL and democratic governance. One of the most important, one of the core, the most essential ingredients, in political and democratic governance. Please, let's note that. Now, this rule of law has two main principles. It has two main principles. And these two main principles are liberty and equality. Liberty and equality. Everyone is equal before the law, and everyone is entitled to liberty before the law. Except, if reprimanded by the court of law, of current jurisdiction. So we have that as that. So now, I said earlier that rule of law is a constitutional doctrine. All right, it has its backings. We're about 4 of us on this stream, and I'm seeing just one like. Please, if you're on the stream, let us make it an habit as you join the stream after saying good evening, hello, just like what Mr. Jackson and Mrs. Regina has done. All right, please let's also do all to smash the like button thereafter. Now, it is said to be a constitutional doctrine, and this doctrine emphasizes the supremacy of the law. All right, does what? Emphasizes what? The supremacy of what? Of the law. All right, the law is supreme. Emphasizes the supremacy of the law as administered by the what? By the law courts. As administered by the law courts. What are we saying here in essence? This constitutional doctrine we are referring to as rule of law emphasizes, speaks at length, all right, makes it essential, all right, that makes it known to all how essentially the law is supreme. All right, law is supreme over everything in a state. Okay, and this is as administered by the law courts. Literally, the law means the governance of law. Okay, literally, the rule of law means the governance of law. Okay, literally, the rule of law means governance of law. This is to say that the entire society, including democratic institutions, organs of government, and the civil society, must be subject to the rules. All right, must be subject, everything within the state. All right, ranging from organs of government, democratic institutions, civil society, are all subjects of the law. Are we together? They are all subjects of the law. So we have that as that, and thus the law is supreme and all must be subordinate. All right, all must be subordinated. The law is supreme and all must be subordinated to it. The law is supreme and all must be subordinated to it. Okay, the law is supreme and all must be subordinated to it. Now let's continue. We have that as that. Now, we have what is called social control. Social control. Now, when we say social control, what are we talking about? It is the control, all right, of social behavior, that is, behavior that affects others. The control of social behavior. Control of social behaviors. Okay, the control of social behaviors. that is the behaviors that affects others. Okay, so we have that as that, and there are techniques. Okay, there are techniques applied to social control. We have, you can either refer to them as tools or techniques. So the very first one we have here is called penal techniques. All right, penal technique. Okay, so we have techniques 1, 2, 3. So we have penal technique. All right, that is PENAL, penal. Then this is the abbreviated techniques. Now, when a person is alleged to have committed a crime, the victim insists, all right, the victim, instead of resorting to vengeance or self-help reports, all right, the matter to the police, and the police takes over. Okay, now speaking of the penal technique, all right, it's applicable to cases whereby one's right is being violated, or one is being abused. All right, so instead of taking matters into your hands, all right, instead of taking matters into your hands or resorting to vengeance, such victim reports the case to the police, and the police, all right, takes it over, all right, takes over from there. All right, and the police get to decide if the person is to charge to court, or maybe something that compensation can be made, and both parties go separate ways. Okay, that's one of the technique, the penal technique. We also have the grievance or remedial technique. All right, while the penal technique involves matter relating to public order or criminal law, all right, public order / criminal law. Okay, the grievance remedial technique is applicable mainly to area of civil law. Grievance remedial technique, all right, applicable of civil law. Okay, applicable to areas of civil law. It provides enforcement of the rights and duties through the law court. Provides enforcement of rights and duties through the law courts. So we also have the what we call the constitutive technique. All right, constitutive. That's the constitutive technique. Now, when we say constitutive technique, what are we talking about? Okay. Now, this technique fosters social order by facilitating the pooling of efforts and resources together, all right, among a group or groups of people to achieve certain desirable social ends, such as promotion of commerce, charitable, all right, social and cultural objective. Here we have foster social order, all right, applicable to fostering social order. Okay, and these are the techniques of social control. Now let's take note of this point. It says here that the principal sources of legal rule, are statutes and precedents. Are we together? The principal sources legal rule. All right, the principal sources of legal rules are statutes and precedents. Statutes and precedents. Statutes and precedents. So we have that as that. Now, when we say statutes and precedents, what are we talking about? According to what we have in the material, statutes is what we refer to as guidance by perception. By percepts. All right, why this is guidance by example. All this will dissect properly, so don't panic. Now, statutes generally come in a clearer set of words. Okay? Statutes generally come in a clear set of words. Okay? A statute should always be looked at as a whole. Okay? A statute should always be looked at as a whole. Now, words used in a statute are to be read according to their meaning as popularly understood, okay, at the time the statutes became law. So let me permit me to erase this so that I can take more points. Okay, so okay. Now, a statute should always be looked at as a whole. Okay, the whole. Now, words used in a statute are to be read accordingly. All right, are to be read according to their meaning as popularly understood. All right, at the time the statutes became law. Please note that a statute is presumed not to alter existing law. All right, a statute is what is presumed not to alter any existing law. Now there's something called not to alter existing law. Okay, are we together? Now we have something called canons of interpretation. All right, there are certain canons of interpretations. Two canons of interpretations of statutes. Okay, canons of interpretation of statutes. Now we have Are we together? Okay, that was a thing from the network. Now, there are certain canons of interpretation. Okay, there are mainly, all right, 3 canons of interpretations of statutes. Okay, so we have, there are mainly 3 canons of interpretation of statute. Okay, statutes. Now they are 1, 2, 3. Okay, there are about 3 of them. So we have the literary rule. Okay, the literary rule. Are we together? We have the literary rule. We have the mischief rule, and we have the golden rule. All right, literary rule, dissecting these 3 canon. All right, 3 canons. Okay, 3. If I write this well, 3 canons of interpretation of statutes. Now, speaking of the literary rule, what are we talking about? Okay, the literary rule. What are we referring to? The literary rule is also seen as the ordinary rule. All right, ordinary, also seen as the ordinary rule, and it is okay, and it is the primary rule of the plain rule. All right, the primary rule of the primary rule. It's also seen as the primary rule or the plain rule. This canon of interpretation is the first, or all right, the first and most commonly used. All right, this first, which is the literary rule, is the commonly used rule to interpret statutes. Okay, it is the most important of statutes. Now it states that where the words used are clear and unambiguous, the court should apply the ordinary meaning of the word as used in reaching a decision. All right, according to the ordinary rule or the literary rule, which is the most common. Okay, it says that when the where the words used are clear and unambiguous, the court should apply the ordinary meaning of the word as used in reaching, all right, a decision. Okay, so now we have the mischief rule. The mischief rule here says that judges express their own opinion as social policy, and this opinion do not always command universal assent. If by any chance the literacy rule, all right, the ambiguity, then the intention of the parliament must be sought. Statutes, judges express their own opinion. All right, judges using their input. Judges all right, using their input, all right, and always, all right, a universal accent, right, meaning that it is limited. The input the judges is using, all right. So in this case, that's why it's called mischief. Okay, mischief in the sense that in the course of interpreting of statute as to social policy, and this opinion do not always command universal assent. So if by any chance leads to ambiguity, leads to misunderstanding, then the intention of the parliament should be sought. All right. So it's not just okay for judges to use their also be sought in order to rectify this ambiguity. Now, at this time, in the interpretation of the literary rule, the intention of the legislator cannot be reached. Okay, now the literal absurdity. Now, the court in such situation allows themselves to construe. When we say construe, we mean interpret a statute in such a way as to produce a reasonable result. All right. At this point, look at the process. There are three processes. The first one, which is the literary rule, which is the ordinary rule and is the most common one, when these words or an interpretation of the statutes lead to no ambiguity. Now look at the mischief rule. The mischief rule says, okay, in a point whereby the literary rule interpreting it leads to ambiguity, judges use their inputs. Still on that, judges should not settle for that. They should sort. All right, they are employed to sort the intention of the parliament, and even at that, okay, even at that, now look at the golden rule. The golden rule now says, at this point, golden rule says at the point of interpretation of the literary rule, the intention of the legislation cannot be reached. All right, now the literary interpretation here leads to absurdity. All right, when the interpretation of the statute leads to absurdity, all right, now the court in such a situation allows themselves to, all right, the court all right, allows themselves to construe, all right, which means when we say construe, it means interpret, all right, so that the court can reach a reasonable what result. Okay, so we have that as that, and on this note, we'll call it a wrap here for today. And in our next class, we'll be talking about designating the area of crime. So thank you very much, everyone. I believe we've been able to gain a thing or two into this class. Please, let's do well to submit our updated notes to the appropriate quarters, because this is very, very important, as this helps us to monitor and ensure you have been following up with classes. Look forward to seeing you all in subsequent tutorial. Do have a wonderful evening. Bye bye.